Hi, good afternoon. Thank you for joining today's webinar. My name is Antonia McIntyre Anderson of Grant Thornton, and my fellow panel members today are Jonathan Addo of Harneys, Colm Edwards of EY, and Shane Quinn of Aegon Litigation. This is the fourth of a five-part webinar series on BVI insolvency practice and procedure, and today we're discussing directors' duties in both the solvent and insolvent context. Please feel free to send any questions that you have via the chat box, and we'll address these as we go along. So the topics that we're covering today are sources of directors' duties, what are directors' duties, recent case law, directors' duties in insolvent situations, practical guidance, and Insolvency Act claims against directors. And I'll now hand you over to Jonathan to kick off the talk with a discussion about sources of directors' duties.
Thank you, Antonia. So good afternoon, everybody. The starting point for the governance framework in the BVI is the Business Companies Act. And probably the best starting point is the definition of a director under Section 2. Because before we even start thinking about whether or not you're subject to, or one is subject to any duties, one needs to determine that they are in fact in the position of a director. And rather nomically, the definition is described as being in relation to a company, a foreign company, and any other body corporate. A director includes a person occupying or acting in the position of director by whatever name called. So I don't know about you, but I don't find that particularly helpful. But generally speaking, if you've been appointed as a director pursuant to an agreement and under the memorandum and articles, and even if you haven't been appointed in such fashion, but you're performing some of the functions of a director of a company, you are likely to be captured by that definition. And there's a whole host of case law that we can talk about in another occasion. But let's just work on the basis that one is formally appointed as a director. So we'll be familiar with what a director of a BVI company is, both in practical and legal terms. A director can be both a corporate and natural person, and is generally involved in the day-to-day management of the company, which raises the question as to why a director is subject to any duties at all. Well, a director is mandated with the day-to-day management of the company, and so the law has imposed upon someone in this role, a role which has been said to be akin to being a trustee, certain fiduciary obligations in order to ensure the proper governance of the entity, as opposed to just the business. It's primarily a framework of fiduciary obligations designed to afford protection to the members who obviously own the company, creditors and other third parties who interact with the company through its board of directors. And the board of directors obviously subject to the law of agency, which the bedrock of which is fiduciary obligations. So the director is in a position of trust, and he or she is therefore held to a certain standard in the eyes of the law. So what happens if these duties are breached? I know we haven't yet got to the duties, but why is it relevant? It's relevant to all of us as professionals because of the risk that arises if these various duties are breached. There are a number of remedies that are available, but generally speaking, any breach will leave a director vulnerable to some sort of suit, some sort of legal action. And the law is clear. Where a fiduciary, so a director invested with these fiduciary obligations, fails to discharge his or her duties, he will very quickly find he's liable to his beneficiaries, in this case the company, if they suffer or it suffers loss as a result. And what do those remedies generally look like? Usually, in the first instance, it will be an injunction or injunctive relief to stop a director from taking steps he or she should not be taking, setting aside of an impugned transaction, restitution, think in terms of returning secret commissions or bribes, and usually, and lastly, damages. I don't want to get too much into the weeds here, but there are two important distinctions also to bear in mind, that if there's a contractual link between the director and the beneficiary, which in this case is the company, and usually there is, then damages are generally available for breach of fiduciary duty. So think monetary compensation. Why do I need to observe these duties? There's obviously this risk of liability, and if that liability is proven, then I'm going to have to pay up. But also there is an added risk in that even if there isn't a contractual link between the director and the company, in the sense that one could be a de facto as opposed to a de jure director, the courts have also allowed damages to be awarded in those sorts of cases, and damages arising out of, for example, economic torts like the tort of deceit, but more likely damages for breach of an equitable or fiduciary duty. So as you can see just from that, directors are exposed or potentially exposed to a high level of risk in their roles, even if your mandate, his or her mandate, is considered to be rather limited. So how do you mitigate the risk of breach? Well, Shane and I have looked at this, and we think that by learning the framework, the basic framework of duties that feed into good governance, which we think reduces the potential for mistakes, you can virtually eliminate breaches or unlawful conduct. So if we could just turn to slide 6, please. Thank you. Well, you'll see there, generally speaking, what the most important duties are that we've identified, but I'll just rattle through them very quickly. The first and most important one, and probably is the biggest no-brainer, is to act honestly and in good faith. You'll see tacked on at the end, acting in the best interests of the company. Now, there's a bit of a question mark as to whether that is in fact a fiduciary duty. In the UK, they've codified that in statute under Section 172 of the Companies Act 2006, and they've characterized it as the duty to promote the success of the company. That isn't a duty that's imported into the law in the BVI, but it is generally the underpinning of almost all of the fiduciary duties that a director is under, because it's the central tenet of a BVI director's fiduciary duties, that you have to act in the best interests of the company. And we'll turn to that a little bit later when we talk about some of the cases. But moving on, a director is required to exercise his or her powers for a proper purpose. That has a very specific meaning in the eyes of the law, and we'll explain that in a little bit more detail as well. Because a director is a fiduciary and an agent, the law of agency says you must avoid conflicts of interest. This includes being subject to a duty of loyalty, so you can't have two principles. And of course, as a subsidiary of that, is not to take a secret profit. Don't take bribes or secret commissions. If you take those sorts of secret commissions, you can bet your bottom dollar you'll be sued and you'll have to hand them back plus damages. There's the non-fettering of discretion. I don't know if Shane wants to explain that in a little bit more detail.
Yes, so in respect of the duties that you've outlined already, directors generally have a discretion as to how they behave. There's a certain test that the court will apply in certain circumstances if a decision is impugned, and really the court's interested to know whether or not, given all the circumstances, whether or not a director has behaved as a reasonable director would. But what's important is that when a director has a discretion, is that he doesn't try in any way or shape to impose restrictions on that discretion as a means of exculpating himself from the duty to exercise the discretion in good faith and in the interest of the company.
Again, we'll come to that in more detail, but the sort of practical examples by which you could minimize your risk in that regard is to exercise your discretion in favor of obtaining professional advice. because of course then you shift the risk away from your own personal prejudices that may infect the decision that you then later on make, and that's what we mean by not fettering your discretion. Give it to someone with an independent view who can come back and tell you, rightly or wrongly, whether your decision should be A or B. And then lastly, of course, and this is quite connected to the duty not to take secret profits and avoiding conflicts of interest, is not to misuse, or even worse, misappropriate the company's property. Don't nick your company's property, is what that means. So I'm conscious that not everybody attending the webinar is a lawyer. So just to break this down, what we describe as a common law, so these are the common law duties. We simply mean that through case law, the doctrine of precedent, these sorts of issues have been argued, and the courts have held that these are the duties to which a director of a company is subject. Now, fortunately, in the modern era, those duties are now conveniently located, codified in statute, in the BVI, the Business Companies Act, and they are found in next slide. Yeah, so sections 120 to 125, and I'm sure most of you don't walk around at lunchtime with your Business Companies Act by your side, but just to rattle through these statutory provisions. The first one is section 120, which is the honesty and good faith requirement. Section 121, which is the proper purpose requirement. Section 122, the standard of care requirement. That's the objective standard of the reasonable director, which Shane just touched on. And then section 124, which is the no conflicts of interest requirement. So all of those statutory provisions effectively codify, and by that we mean draft into law the common law that has been decided already through successive cases that have come before the courts. So that's the legal framework. So now we want to just put some flesh on the bones. And unfortunately, in the last 4 or 5 years, in the BVI, the courts have enjoyed a steady stream of cases dealing with directors' duties. And there are 2 cases which, certainly from my perspective, 2 cases worth mentioning, which the BVI courts themselves have been able to examine both the English premises upon which a lot of these fiduciary duties are based, and explain in sort of BVI language, if I can put it that way, for the purpose of the BVI market and industry, what the honesty and good faith requirement means, and also what the proper purpose requirement is. And the first case in time, and this is actually a proper purpose case, is the Court of Appeal case of Independent Asset Management Company Limited and Swiss forfeiting. And the facts of the case were that the defendant company was formerly a forfeiting fund that was deregistered in the BVI and became a normal company after its business effectively failed. It was a joint venture, and both parties quite acrimoniously fell out with each other. And the 2 parties that are in the case itself, so Independent Asset Management Company Limited, the claimant, was the former manager or asset manager of Swiss Forfeiting Limited. IMC was also a shareholder in Swiss Forfeiting Limited as part of its asset management agreement. And the share capital in Swiss Forfeiting had been divided, like most funds often are, into A shares, where the voting power lay, and B shares, where the economic benefits lay. And IAMC owned 100% of the voting A shares, and the beneficial owner of the B shares had a Singaporean PTE through which he held the B shares. And the 2 of them fell out. And when the parties fell out, the evidence at trial showed that the dispute of which the directors were aware between the 2 shareholders had become extremely hostile. And the board of directors were persuaded, unfortunately, by the B shareholders to issue fresh A shares. Now, as I've explained, the claimant was the 100% shareholder of the voting shares, so he had all the voting power. He could change board of directors, or it could change board of directors. It could make other calls on how the company could be run. under geomatic principles. But behind its back, the B shareholders had got effectively into bed with the board of directors, who agreed to put their hand on the scales in this hostile dispute between the two parties. And they issued via a directors' resolution a fresh issuance of shares in the A class, and that tipped the majority in favour of the B shareholders. IMC went from being 100% to being 16% and having absolutely no control whatsoever. There was a dramatic shift in the balance of power away from IAMC. So the fiduciaries, the board of directors, had, instead of staying above the fray, completely entered the fray. Now, IAMC sued the company under Section 184B under the Business Companies Act and succeeded on appeal. It succeeded on appeal because the trial judge found at trial that the board of directors had deliberately diluted IAMC's shareholding in order to favour the B shareholders. But the judge had sympathy with the B shareholders and said that act of the fresh share issuance by the board of directors was in the best interests of the company. Now, that decision was in itself the basis of the successful appeal, because IAMC argued that the judge had misapplied the proper purpose test. They said, and the Court of Appeal agreed with IAMC, that where a question arises as to whether a power conferred on a director was exercised for a proper purpose, the court must conduct a four-stage test. And once you've completed that four-stage test, the best interests of the company do not come into any of that analysis. So the four-stage test is effectively this: that you have to identify firstly, and this is what a director would have to do when faced with this sort of dispute between two shareholders. Identify the power whose exercise is in question. So if you're asked to do something, for example, a share issuance, identify what that power is and what you're seeking to exercise. Identify the proper purpose for which that power was conferred upon you. Okay. And then identify the purpose for which that power is in fact going to be exercised. Again, this is the sort of thing that you will need professional advice for, so that you make sure that you get these tests right. And then at the end, the court would have to decide whether that purpose was a proper purpose. And once the court conducted that exercise afresh, it essentially said this, that the rationale behind the proper purpose rule is that directors should not issue shares in a manner that could affect the balance of power between groups of hostile shareholders, of warring shareholders in the company, as to create a new majority. And this is exactly what happened in this case. The directors created a new majority by the fresh issuance. And it doesn't matter for the proper purpose rule whether the old or the new majority did not have a proprietary interest in the company or in the success of the fund as it was at the time. So the basic rule is that the director's purpose, however noble, should not be used to affect the balance of power in the company. And if it's used in this way, it's an improper use of the power and is liable to be set aside. And that the court applied the leading case of Howard Smith and Ampol and sections 121 and 184B of the Business Companies Act. So you've got a particularly specific example of BVI law being applied to set aside a director's share issuance where the directors were improperly persuaded by one side of a warring faction amongst shareholders. And that's the case even if the share issuance results in additional capital or other benefits coming into the company. And the restriction's not written, it's not written into the company's articles. And it's for this reason that the law imposes on the directors this additional requirement that shares must be issued for a proper purpose. That's the proper purpose rule. There was one other case that I thought I'd just very quickly touch on, which was very similar, and that's the Anto Holdings case, Best Nation Investments versus Anto Holdings. And in this particular case, I'm not going to go into the facts because they're actually quite complex, but there were two impugned transactions, and there were transactions that had effectively been caused by the board of directors, again, who'd been persuaded to act on the behalf of one particular side of the company. And in this case, what's slightly different from the independent asset management case is that the court also considered what's known as the Charter Bridge test. And the Charter Bridge test applies to the good faith and honesty element, so the subjective elements of a director when facing the sort of decisions that they often have to make about whether to exercise their powers in a specific way. And in this case, the court effectively said this, that under Section 120 of the Business Companies Act, where a director has failed entirely to consider the interests of the company at issue, his conduct will not be analysed by reference to the usual subjective test. So the test will be whether an intelligent and honest man in the position of a director could, in all of the existing circumstances, have reasonably believed the transaction was for the company's benefit. So unpacking all that legalese is basically stepping back and saying, even though the directors may say, as they did in this case, say that it would be much better for the harmony and it will improve the prospects of performance within the company if we take these steps to benefit that majority as opposed to that majority. The overriding test is whether or not an intelligent and honest man would think that that is the best, in the best interests of the company as a whole. So that's where the best interest test comes in. It's not in the proper purpose test. It comes in when the court is having to grapple with whether the steps taken by the company directors are honest by general objective standards. So the man on the Clapham omnibus, so to speak. So that's known as the Charter Bridge test. They also had to consider as well under Section 121, which is a proper purpose test. And they also agreed that the acts of the board of directors, again, on very similar facts to independent asset management, whether they had the substantial purpose had been a proper one, and they said, applying their earlier decision in independent asset management, they found that it was for an improper purpose. So again, the transactions were set aside. Okay, this particular case is perhaps an example at the extreme end of the spectrum, but the Court of Appeal described the BVI directors' motives as being self-serving and for personal advantage, but in fact they'd actually gained some money from it. So it's just a cautionary tale to say that where directors are wearing multiple hats, and that calls into question the conflict of interest issue that we touched on earlier. What could be seen as honest behaviour is likely to be called into question. So one has to look at whether or not the acts taken by a director are in the best interest of a company. And so to avoid an outcome in which the Charter Bridge test, this intelligent and honest man test, is applied, where you're unable to rely upon your subjective honesty, or I did this honestly in the best interest of the company. It's actually an objective test the court's going to apply. Directors are better advised to consider the interests of each company or each transaction and to document their rationale, and usually to get specific professional advice for any transaction accordingly. So that's all I wanted to say about those two elements. I think Shane has some thoughts arising out of two other cases that have gone to the Privy Council and the BVI, Saiban and Byers and Chen, which touch on some other elements of duties of directors.
Yes, thanks very much, Jonathan. I should just say, just for the sake of keeping this up to date and very current, that there was a decision just last week by the Court of Appeal. It's called Amstel Investments and AMS Holdings Limited, which essentially confirmed all the points that you've just made. So it's relatively hot off the presses, but it went through the four factors that you've mentioned, and then also reaffirmed that the test in the BVI in respect of the exercise of a proper purpose is whether or not the purpose in question was the dominant or substantial purpose. The two cases I'm going to come on to, the first one is Saiban. Jonathan mentioned already that the definition of a director can be found in Section 2 of the Business Companies Act, and I suppose it is unhelpful and laconic in its own way. But one of the types of directors that it doesn't capture is what's known as a shadow director, and that's generally someone who is not holding themselves out to be a director or behaving in a way which is consistent with the director in office, but as someone who is perhaps like a Cyrano de Bergerac, if I can put it that way, who's exercising influence over those who do actually hold the office of director. Quite often you see that where a company has got itself into financial difficulty in respect of one dominant creditor, and that creditor then can take almost absolute control over the actions of the board. And sometimes that can give rise to an accusation that a creditor is, for example, behaving like a shadow director, though without going into any detail, I think the jury is still out, for want of a better expression, on whether or not creditors can properly be described as shadow directors in those circumstances. But the reason I mention that is because in the Cybank case, and Jonathan had mentioned this already at the start, which is it's possible, and indeed it's quite common in the BVI, that the sole director of a BVI company will itself be a company. And in the Cybank case, there was a particular company which was beneficially owned by, we'll call him Mr. B, and the company was called Spectacular. The sole corporate director of Spectacular was another company called T Limited, and it received its instructions not from Mr. B, but from a third party called Mr. C, who was a close friend and associate of Mr. B. So in practice, if anyone looked at the paperwork, for example, it would have been very difficult to link Mr. B to the direction and control, let alone the ownership of Spectacular. As is common, and Jonathan touched on this in the joint venture case that I mentioned earlier, these people tend to fall out, and I suppose that's the nature of litigation. These cases tend to arise out of the breakdown in relationships. So Mr. B and Mr. C fall out over a supposed debt that Mr. B owed to Mr. C. And what Mr. C does is he uses his position as the sort of day and daily manager of T Limited to put through a transaction which allows him to satisfy the debt which he says Mr. B owed to him, and then he transfers the balance on then to Mr. B. And of course, then this gives rise to a dispute as to whether or not what Mr. C had done was lawful. But in the crosshairs, in this case, was actually T Limited. That's the corporate director of Spectacular. And the court looked at this through, I suppose, three questions. First and foremost, I think, was, well, if Mr. B has set up his company Spectacular in such a way that its director is itself a limited company, and then that limited company is in turn daily controlled by Mr. C, a third party, who should bear that risk? Is that really for the court to intervene and say Mr. B has now been treated unfairly or has in some way not had oversight over a particular transaction, and the court should set aside that transaction? Or should Mr. B accept that the way in which he structured this particular corporate structure was such that there was a risk that he would not particularly have control over what was going on, and he should just live with that risk? And essentially, when it got to the Privy Council opted for the latter interpretation, and it simply said that he chose to take the risk of betrayal and was stuck with that risk and could not thereafter ignore that risk and try to attribute blame to T Limited, the corporate director. The second question then that the court looked at this problem through was, well, what about situations where someone is holding themselves out to the world at large as having the authority to act on behalf of another company or to control another company? And this is termed the ostensible authority issue. And basically, again, both Mr. B and Mr. C to third parties, particularly in the facts of this case, putting together powers of attorney, had held Mr. C out to be a legitimate controller of the corporate director. And so again, on that particular point, Mr. B couldn't complain afterwards, having held Mr. C out as such, that it was unfair that Mr. C had directed T Limited to behave in the way which it did. And the third question, and this is really the interesting one really in this particular case, There is a principle of common law known as the geomatic principle, and forgive me if I'm explaining stuff people already know. But in essence, the geomatic principle arises out of a case, Ray Geomatic. It's a relatively old case now. It's from the 1960s, and essentially that principle says that where it can be shown that all shareholders who have a right to attend and vote at a general meeting of the company agree to some matter which a general meeting could actually carry into effect, then that agreement is binding as a resolution in the same way as if it had formally been brought to a general meeting. And in big corporations, obviously that doesn't make much sense, where there could be many disparate shareholders, but in tightly held companies, particularly in the BVI, where, for example, a family might use a BVI company essentially as a money box, and you may very well have 2 or 3 shareholders, a father, a son, and a daughter, for example. If they all agree to a particular course of action, the company can be bound to that agreement, notwithstanding that a general meeting didn't take place. Why that was relevant in the Cyban case was that essentially Mr. B in that particular case may not have had actual knowledge of what Mr. C was doing. Mr. C had obviously gone behind his back, directed T Limited, which is the corporate director of Spectacular, to put through a particular transaction. But the very concept of ostensible authority meant Mr. B could not be allowed to deny that he consented to the giving of the authority. So essentially, Mr. B was bound by the geomatic principle in that particular context as well, because that's the way in which they'd held this particular structure to operate. And although Mr. B might have, in one view, been a very sympathetic person, I suppose that the Privy Council was alive to the fact that, I suppose, in the background, Mr. B did in fact owe a debt to Mr. C, and that may very well have influenced the particular approach in that case. I'm very conscious of the time because it has just gone past 1:30 in the BVI. But if I could just briefly mention another Privy Council decision, which is Byers and Chen. Now, this traverses a number of particular issues, but again, it involves layered corporate structures and exactly how that happens to affect particular decisions. In essence, there are a number of issues that come up here again for consideration by the court, but I'll focus specifically on the breach of duty. In summary, what had happened here was that a company which had already been in a dispute with another party, it was a freight forwarding company, and it entered into a number of contracts, and a number of disputes arose out of them. On the last day of a particular case that was ongoing, the company considered that itself was insolvent, and it was entering into a situation where it was insolvent. And I understand Colin and Antonio will talk about these particular situations in more detail in a moment. But subsequent to that, Miss Chen, who was there was a dispute as to whether or not she was still a director at the time, but basically the Privy Council held that she was. But essentially, she had stood by and allowed the payment of a debt to a particular creditor to take place, and that in circumstances where the company was already entering into an insolvency situation, amounted to an unfair preference of one creditor over other creditors, notably the potential judgment creditor arising out of the case that the company was engaged in. There are lots of other issues and moving parts in this particular case, but on that particular point, I think it's very, very interesting because what the court has said, that the Privy Council said that basically a director in circumstances where the company in question is insolvent, or it's an issue where there's a doubt as to the solvency of that particular company, cannot stand idly by and watch the assets of that company be depleted. Now, I think that raises a very interesting question in this particular context, because as I mentioned earlier, in the BVI, you often have quite tightly held companies. Often there are no more than family partnerships, but incorporated as limited companies under the Business Companies Act. But the prospect of being a non-executive director in the BVI might be you can take to mitigate the risk of being exposed for a breach of fiduciary duty. But in circumstances where the court now has actively saying to directors, you cannot stand idly by and watch something happen. You must take positive steps to intervene. I think the office of a non-executive director in the BVI now is now all of a sudden, I suppose, posed with a certain risk that even those non-executive directors might be attached to certain liability in circumstances where the company has entered an insolvent situation. And I suppose on that note, I think then Antonia and Colin wanted to talk about, well, what exactly does a director have to do, or what should a director not do in circumstances where the insolvency of the company has become apparent?
I just wanted to say, I just wanted to say very, very quickly that if anybody attending has any questions, please just fire them into the Q&A or chat function here, because this is meant to be interactive as opposed to us giving you information you may already have in a talking head session. So we may also have questions amongst ourselves as well, so you'll have to bear with us. But please do drop us your queries. Sorry.
Thank you, Jonathan. Thanks, Shane. Shane, as you said, at all times, directors of a company incorporated in the BVI, they need to be aware of the roles and responsibilities as the director. And that's in particular where a company is solvent or of doubtful solvency. If we move on to slide 11, directors' duties where a company is insolvent. So this is the first scenario. When a company is solvent, the economic stakeholders whose interests are at risk are usually the shareholders, and their investments require protection. At this stage, it's the shareholders take paramount, and the creditors take a back seat just from here on in. The duties of director of a BVI solvent company arise under the common law, BVI Business Companies Act, and the company's own M&A. So you can, if it's the duties of a director is going to be outlined in all three of them. The director of a company owes duties to the company as a whole and the shareholders, whilst the company is insolvent. And this doesn't just apply to directors listed on the register of directors, it also applies to the de facto directors. So, that's the persons who act as director, but you just don't have the title. So that's when a company is solvent. But when a company is insolvent or even of doubtful solvency, is the company's creditors whose interests are at risk here, not necessarily the shareholders of the company. And this is the exact point where the change in directors' duties from shareholders to creditors takes place. So where a company is in the zone of insolvency, directors of a company should, as far as possible, consider where it's apparent that the company was likely to become insolvent. And that it's from that stage onwards that the interests of the company's creditors should have been given paramount consideration ahead of the shareholders. It's a little bit difficult because the precise point at which the duties of a BVI company's directors begin to include duties to the creditors of the company is difficult to identify. And the courts so far have struggled in the BVI to prescribe a definitive legal test. I'll come on to that in slide 13. In slide 12, when will a company be deemed insolvent? I'm aware this was covered, I think, in the first webinar back in September, but just the main points, the meaning of insolvency. This is covered in Section 8 of Insolvency Act 2003. And there's four main criteria. One is the failure to comply with the statutory demand not set aside. Second, unsatisfied judgment or order of a BVI court. Thirdly, the company's liabilities against assets, that's the balance sheet insolvency. And then the company's inability to pay its debts, that's the cash flow insolvency. So if a company does end up in liquidation, either via the appointment of a liquidator by a members qualifying resolution or via court application, then upon the appointment of a liquidator, the control of the company is handed over to the liquidator, and directors cease to have the power to manage the business and the affairs of the company. The director also would be given statutory powers of investigation, and the liquidators will require directors to complete a statement of affairs and also call for documentation to be provided by directors. And if necessary, the liquidator can also conduct examinations of directors and officers. And that goes into personal assets of directors and company officers also. The Insolvency Act would also provide for a number of claims the director can bring in order to recover assets to make up a shortfall in the company's assets to pay creditor claims. So if there was assets outlined in the statement of affairs and following investigation by the liquidator, we realized there was more assets in the company, and those assets have since been liquidated and the funds have gone missing. Well, then the liquidators can actually bring an action against the directors. This happens in there's mainly two categories that this would happen in. If directors had malpractice claims, this is where the companies carried on business improperly, and claims can be brought against the persons who caused the company to act improperly, and that's usually the directors. And there's also a claim can be brought against voidable transaction claims. This is where the companies enter into transactions that are voidable under the Insolvency Act. But this normally relates to third parties who benefit from the transactions, and not necessarily against the directors personally. But directors, as I find already, can be action can be taken personally under malpractice claims. In slide 13, when does the director begin to owe duties to creditors? Again, this is quite difficult to establish. In recent case law, the Court of Appeal of England and Wales found that a duty to creditors may be triggered when a company's circumstances fall just short of actual established insolvency. Then it went on to find that the duty arises from directors known or should have known that the company is or is like to become insolvent. So basically, as soon as directors of the company know that, listen, we're facing insolvency here, we're 6 months away from insolvency, or we're 2 months away from insolvency, the attention then really should be directed to the creditors and protecting the assets of the company rather than protecting the shareholders' investment. It does remain difficult to determine the precise point following which directors to take into account the interests of the company's creditors, and disputes are normally judged on a case-by-case basis. So there isn't any definitive case law at the moment. If a director considers that the company is or like to become insolvent, they should immediately seek professional advice from a BVI insolvency or a BVI insolvency practitioner. These case laws have only recently gone through the courts of appeal, and we're expecting a Supreme Court decision later on this year, is my understanding. Antonia?
Okay. So just moving on what should directors do when they realise that when they become concerned about the company's solvency? So there's a number of steps that they should be taking. Crucially, they should consider monitoring the financial position on a regular basis and consider any potential trigger events. Any decisions that they make in relation to ongoing trading of the company should be properly documented. Directors should also seek professional advice at an early stage, and the earlier the better. Again, the decisions made on the back of advice sought should be properly documented. In the event that directors find themselves in court, these documented decisions may well assist them in defending the actions that they took. They should consider notifying D&O insurers at the earliest opportunity, and that this may reduce the risk of an insurance claim being restricted. And they should also give consideration to commencing voluntary insolvency or restructuring process, and the appropriate solutions should be identified during discussions with professional advisors. So Colin touched on the various Colin touched on the various claims against directors under the Insolvency Act. So where a company ends up in liquidation, the liquidators have statutory powers of investigation and will require directors to produce a statement of affairs and provide certain documents. A liquidator can also conduct examinations of directors and officers before the court. So the Insolvency Act 2003 definition of a director expands, and I know this has been touched on earlier, it includes executive and non-executive directors and may include de facto and shadow directors. So these actions aren't just against directors who are listed on the register of directors. Part 9 of the Insolvency Act deals with malpractice. And it's important to note that these provisions under Part 9 only apply where companies have entered insolvent liquidation. The Section 254 of the Act deals with summary remedy against delinquent officers. And a court might find against a director where they have been found to have misapplied, retained, or become accountable for any money or assets of the company, or have been found guilty of any misfeasance or breach of any fiduciary or any other duty to the company. And this section is basically a catch-all, so anything that's not covered elsewhere with an action could be taken under this section. Under section 255, the court can make an order against a company's director if it's satisfied that the business of a company has been carried on with the intent to defraud creditors or for any fraudulent purpose, and that the director was party to the fraudulent trading. Section 256 deals with insolvent trading, where directors can be found liable for insolvent trading where they knew or ought to have known that there was no chance that the company was going to avoid going into insolvent liquidation, but failed to take steps to minimize losses to the company creditors. And under each of these sections where the court finds that the director is liable, so for misfeasance, fraudulent trading or insolvent trading, it has wide discretion as to the amount in which a director should personally contribute to the assets of the company. Under Part 10 of the Insolvency Act, a director may also be disqualified from acting as a director of a company or from being directly or indirectly involved in the management of a company. A disqualification order may be made by the court if the director has been convicted of any offence in relation to an insolvent company, is guilty of fraudulent trading or insolvent trading, or is guilty of any fraud or misfeasance. And the director found to be in breach of a disqualification order is liable to fine and or imprisonment. So that concludes our presentation, and we can move over to any questions now. I think we've got one question through here.
Can you see one?
Oh, sorry, just give me. Okay. Okay, so question here, are directors' duties and responsibilities always aligned in terms of the Business Companies Act, common law and approved person status with a regulator? So for example, if a ban is imposed for a period of time, is the time period the same in each instance?
I mean, I think that's quite a technical question. I don't know the answer to the last bit. That requires some research. I don't know if it bears any real relevance on the first bit, about whether or not their interests are aligned. But you can tell from the what we've discussed in the last 50 minutes that they're clearly not aligned. That the interests bite in different ways at different times in the maturity of the company, and differing external and internal pressures require different forms of decision making by the director. The director's given an awful lot of power, being invested as a fiduciary. The day-to-day management of the company, and a lot of decisions flow through those directors. But the corollary of that is that you have to engage in sensible decision making, and you also have to sort of see the directors a little bit like those Russian dolls. That probably right at the core of it is the interests of the company. But outside of that, the next level would be, well, what are the interests of the company, or the success of the company? But also interwoven with the success of the company is ensuring that it's able to ward off threats, and that it behaves as a responsible corporate citizen. And that's not just sort of ESG concerns, it's also as regards to its creditors, its suppliers, its investors, its shareholders, and the market generally. So there is actually a lot that goes into being a director, and I can imagine that some people who may have dialed in could be a little bit deterred by all the different pressures that you're under when you're just a nominee with a specific cookie cutter fee in the BVI marketplace. You might wonder why you do it, but the thing, you would do it because it's actually probably quite rewarding. You have a lot of control if you use that control appropriately, but the way to make a non-exec type role, let's use the term nominee because that's really what we see in the BVI, worthwhile, is to make sure that you know what's going on, because at different points there will be different pressures and requirements of you, as a fiduciary, and the thing is to know when you need to do something and when you don't need to do anything. And sometimes that's not an easy call. That's why it's okay to call your lawyer or an IP to say, what should I do in this situation? Have you ever come across this? What did you do? How did it play out? I think that's what we're trying to convey today.
Okay, now we've got another question. Has excessive regulation stifled interest in being a non-executive director? But I think you've probably just covered that. I don't know if anyone else has got any comments on that.
Shane, have you got any views on whether I don't know what successive regulation there has been. I don't think there's been any successive.
Sorry, excessive regulation.
Excessive. Well,
excessive,
yeah. I mean, one of the wonderful things about being in the BVI is it's light touch and pro-business. There's no excessive. I don't think there's any real regulation, save for the common law and the statutory framework that we've set out, and the flesh on the bones is how the courts have interpreted conduct. So I don't know if Shane, if you have any views on that.
No, I don't think it could add very much. There sometimes can be a cooling effect if too many decisions come out that are far too critical or commercially unrealistic. I only mentioned the Chen case because it was so recent, and just the court had taken a very clear view that directors are directors and they should be proactive, particularly when the company is in an insolvent situation. But I think that might reflect a pro-creditor stance rather than an anti-director stance, if I can put it that way. So I don't think there's a necessarily a reluctance that I can see happening because of any particular case or legislation recently. But it just is interesting sometimes to see the tension in the judgments between the court being quite clear that the BVI is not a place to hide from your creditors, but at the same time also being quite clear that it's a very open pro-business economy.
I mean, it's good for the jurisdiction, because pro-creditor is what we need. Bad for the people involved with Chen in that case. But yeah, it's I think the courts are trying to tread a delicate line, aren't they, at the moment, and encouraging the industry, but making sure that it follows similar tenets to a pretty Anglo-centric legal history that has formulated a lot of these fiduciary tests and duties. I think I agree with that. Yeah, a couple of questions. There's some questions in the Q&A, Antonia.
Oh, I'm in the wrong. Thank you. I'm in the wrong area. Okay, so we've got a question here. Whether statutory look-back period under which directors can be held liable for a breach of duty has expired, are there any options to go after a director for, say, fraudulent trading or the like at common law or under the Law of Property Conveyancing Act?
Shane, you want to tackle that?
Well, I think the short answer is where there's fraud involved, there's no limitation period at all. So the look back period is indefinite. If you've uncovered a fraud at any stage, it doesn't matter whether it's to do with shares or land or cash or a company, the look back period is indefinite. I'm just trying to read the rest of the question here. Yes, fraudulent. Yeah. Fraud, even in basic statutes of limitation around the common law world, fraud is not subject to the usual sort of 6-year limitation period that you would see for breach of contract or something like that.
I think what you mean is the vulnerability period, and obviously the vulnerability period opens up the misfeasance provisions under the Insolvency Act, but you don't, a liquidator's hands aren't so tied to those provisions as a means to recover assets or value into the company. There are economic torts, there are, unlawful means conspiracy, there are, other means by which either a naughty director or a third party can be pursued when the company is in a insolvent, in a liquidation situation. So you're not bound to follow only the misfeasance provisions under the statute in order to try to recover proceeds for the benefit of the estate. I hope that helps, Merrick. Next, another question.
Okay, on a regulation point, how serious is the BVI for punishing delinquent directors and issuing disqualification orders? I think in my experience, not very. So go on, Colin.
Yeah, I can feel that, Tony. It's more, I think, got to do with the location of the directors and cost involved as well, because these companies obviously have already been entered into liquidation. They're insolvent. There's going to be a lack of assets, lack of funds, and for the creditor to go chasing additional punishment for directors and trying to locate these directors wherever they may be around the world. I think it's more of a cost, more of a question of are there funds available and the cost involved, rather than the BVI not having any appetite to go after or disqualify directors. If there's cost, sorry, go ahead.
Yeah, no, sorry, Cole, I cut you off.
No, go ahead.
I was just going to say that's all. You're absolutely right. There is a geographic and extraterritorial element to it. You know, what is the point of penalising someone who isn't in the jurisdiction, is never going to step foot in the jurisdiction? And if it's been layered in such a way that you've got corporate directors and then, you know, layers of other different corporate directors all around the world, it makes it impracticable, or impractical, not impracticable. But the courts are taking a much more robust approach now to contempt, to court orders that haven't been obeyed, to people effectively, you know, playing hooky with the legal system. So there is the real risk that a court could still take the view that a director ought to be disqualified, whatever form that director may take, or prevented from acting as a director, and, you know, penal sanctions being imposed. Difficult to know what the impact of that is, but yeah, there's certainly been an attitude shift amongst our judiciary about using these sorts of tools that, but for the fact that people aren't in the territorial jurisdiction of the court, they are getting more than just a slap on the wrist. I don't know, Shane, if you agree with that, but it seems to me that is the mood music.
I think that's right. There is one additional element to this, which is where the sole director of a BVI company is itself a company. There's case law on this, I think, from the UK Supreme Court. Holland, I think the case is, just off the top of my head. The owners of that director company won't necessarily be considered de facto or shadow directors of the target company, if we can call it that. So there can be difficulty as well for a liquidator in certain circumstances going after an identifiable individual. It's not even just a matter of resources. It can just be an almost fruitless exercise.
Okay, and finally, I think we've got 1 minute left. In insolvency situations, are duties owed by directors to secured creditors to the same extent as unsecured creditors? Will it ultimately depend on whether they are fully secured for their debt?
Who wants to answer? I think Mungo probably knows the answer to that better than we do. It's a trick question. I've never seen any case law that suggests that the duties are in some way minimized to a secured creditor. The law has always just used the term creditor, but there may be, and I'd have to look. Honestly, I'd have to look, because I don't know the specific answer to this. But it would seem to me that the duties are coextensive, whether it's a secure or unsecured creditor. The question, I suppose, becomes more refined when the company is in liquidation. And it will, I suppose, depend on whether or not the secure creditors have elected to enforce their security before insolvency, before the appointment of an insolvency practitioner over the company, or not. I suppose it's a sort of a weird retroactive analysis that you'll have to engage, because, you know, at that point a liquidator probably doesn't know what the best thing is to do for a company, but the creditor has more information and more opportunity to realize value. So I think it's a very good question. The answer to that, I'm not entirely sure. Don't know, Antonio, if you have any experience of that.
No, I don't, yeah, I'm not entirely sure either.
Yeah, my
Mhm.
my feeling is, and I'd be interested to know what Mungo, if he wants to jump on the audio, thinks about that. Well, my feeling is that there is no distinction. The duty at the point at which insolvency arises, or when the directors know or should know that the company is about to tip into insolvency, the duties are the same, whether it's a secured creditor or not. I think that's the approach that I've generally taken. A secured creditor is in a better position, of course, because they can very quickly take over the company if they so wish. But that doesn't mean that the duty that the director then comes under isn't the same. I don't know, Mungo, what's your actual personal view on it? You have to emerge from the metaverse to tell us what you think. Can you speak? I don't. Maybe you can't.
I'm not sure. I think we'll have to pick this one up with Mungo later.
Yeah.
Anyway, that's 2 o'clock. Thank you everyone for joining us, and that concludes the presentation.
Thank you.
Thanks, guys.
Thank you.
Thank you.